So while we've just seen or got a broad flavor of what an arbitration proceeding looks like, it is, in order to summarize, we will mention a few stages, or rather the complete stages of how an arbitration proceeds. So, like I said, the initiation of arbitration takes place when you issue a notice of arbitration, which is then followed by the response to that particular notice, which is then followed by appointment of arbitrators. In that appointment of arbitrators also, there is a possibility of separate court proceedings by way of section 11, which we've discussed. After that, once the arbitration is supposed to commence, the arbitrators are appointed. Then comes the stage of a first procedural hearing, wherein the tone is set for the entire arbitration, timelines are set. Then comes other sundry proceedings, where a party, either by way of a section 17 or a section 9, can claim for interim relief, or a party can choose to file its jurisdictional objection by way of a section 16 application. Then comes the stage of a trial hearing. Before that, needless to say, there is a stage which each arbitrator nowadays enforces, is the stage of points of determination, that is framing of issues, to know that what the arbitration proceedings should focus on, or the award should focus on deciding. So then comes the stage of hearing, your evidence stage, and then the passing of an arbitral award. After the award is passed, there is a period which is given to the party against whom an award is passed to challenge the award, which is supposed to be done within 90 days from the date of the award. And once the stage is over, the challenge of the award is over. If award remains unchallenged, then you proceed towards execution of the award, which is akin to execution of a decree of a court. So having summarized these stages, now we'll deal with each of these stages in greater detail for your understanding.